this is Angela Erickson, Family Service Director at Forest Lawn Funeral Home and Cemetery in Omaha, Nebraska. Today, we're going to talk about estate planning and answer some of the questions that come up often as families put their plans together. Joining me today is Dan Dittman, estate planning attorney at Erickson Sederstrom law firm right here in Omaha, Nebraska. Welcome, Dan.
Thanks for having me, Angela. I appreciate it.
Well, Dan, why don't you tell us a little bit about yourself and your background in estate planning?
Yes, I've been practicing law for about 10 years. I'm a partner at the law firm, and I'm from Omaha, born and raised, and have a family. I have 16-year-old triplets, and they keep me hopping, but I love practicing law. That's all I do. Erickson Sederstrom is a full-service law firm. We handle just about every area of law that one could imagine, but all I do is focus on estate planning, and that's what I wanted to do when I went to law school. Graduated from Creighton Law, and sometimes when I'm not with family and not practicing law, I'm an adjunct professor at Creighton School of Law as well, and I teach an estate planning class, which I really love.
Wow. Triplets. I am impressed.
Yes, it was quite a ride.
Yeah. Okay. So Dan, how do you approach creating a comprehensive estate plan for your clients?
Well, the first thing, Angela, is to get to know my clients. A lot of times people come in, I've never had a chance to work with them before, and I want to get to know a little bit about them, their family, what they value, and really take a conversational approach to it. From there, we can dive into specifics, but if we don't have that, personal connection, a little bit about their family history and things that are important to them, it's hard to put a good plan together. So I really try to make things as personable and as easy as possible for my clients.
I think that's really important, is really asking a lot of questions to get to know your customer and find out what's important to them and what would benefit them the most. We find that helpful in our industry as well, is to be able to put a plan together for them. We have to ask a lot of questions and know what's important to them. So when I think of estate planning, I think of, kind of like puzzle pieces. There's many different pieces of the puzzle. Can you tell me, how does end-of-life choices or cemetery and funeral plans fit into that estate plan?
Yeah, it's very much part and parcel with what I do. And so when clients call me, they're very interested in, getting their will redone, or getting a new will for the first time, getting power of attorney documents. And that's what people kind of think about what estate planning is. But it's actually much broader, because that's just, again, a part of the puzzle, like you said. Funeral planning, I take the approach that to really have a good plan, what are we trying to accomplish? We're trying to make things easier for their loved ones, to make it smoother, to transition both their wealth, but also including things like their final arrangements. And so I find that sometimes I think estate planning attorneys will kind of forget about that piece, and it's an important conversation to have with the clients. So very crucial.
It really is, because when we help families, it's important to have their plans in place ahead of time, because that tells their family and their children what was important to them, and it allows them to follow their wishes. Otherwise, we find that family members or loved ones are guessing or constantly second-guessing themselves, as if they did I do the right thing? Did I do too much? Did I do too little? Is this what he or she would have wanted? And it can be confusing and stressful at a very difficult time. So it's very important.
Absolutely. Why add extra stress when you're already grieving?
Yeah. And we serve many families, and a lot of those families are pre-planned. And I tell you, the difference between a family that has no arrangements versus a family that has pre-plans, it really is a night and day difference. I say this often to our clients. I've never had a family walk in and be upset that somebody had pre-planned and made those arrangements ahead of time for them. So usually they're grateful, they're thankful, and they're just very appreciative that it's been taken care of. You mentioned a will, and I think a will is so important. Can you tell me a little bit about what happens if someone passes and no will or no plans have been made?
Yeah. Well, sometimes that can have very odd results under the law. So first off, when people don't engage in even basic sort of estate planning, I would say that oftentimes there's a fair level of chaos that ensues with the transfer of assets and who gets what. Nebraska law does provide, as all states do, provides a backup plan for you if you don't have a will. And those are called the laws of intestacy. I know it's a boring legal term, but that's where Nebraska says, well, we'll determine where your assets go. A lot of people think, well, if you don't have a will, the state takes all your money, and that's not true. But the state does say who your rightful heirs are in that case. And so, for example, one of the things that happens routinely is spouses or a married person will die without a will. And you would assume that if they're married, their spouse would receive everything just by that law of intestacy that I spoke of, and that's not the case. Kids are entitled to a big portion of an estate when you don't have a will. And sometimes those kids might be minors, those kids might have disabilities. And so, again, those falling back on what state law provides for you if you don't have a will or some other sort of instrument can sometimes be quite different than what you might want to have happen. So this is your estate planning is a client's chance to take control of that. People spend their entire life building up wealth, whether it's small, whether it's large. I have clients of every sort of economic stature in life. And that transfer at death to whomever your heirs are, that will be the biggest financial transaction that you will ever be a part of. And I suppose if you're deceased, you're not really a part of it. But if you think of it that way, it's really kind of sobering because, again, it's a lifetime of accumulating assets, accumulating things, and at death, it's got to go somewhere. And it's your chance to control that and have a good plan that doesn't cause chaos.
Sounds like a lot. Now, you mentioned assets, and we've kind of been speaking about the assets. What if somebody has liabilities and debts?
The estate process, whether there's different ways to plan your estate, but let's say the traditional way that you have a will and you have a probate estate, that entire system through the court system is designed to basically to make sure that creditors can get paid if their debts are legitimate and provides an orderly process for that. Sometimes the probate scheme or the probate laws sometimes get a little bit of a bad rap and a bad moniker because it sounds awful, but probate is really a process to make sure that people who have legitimate claims can get paid back after your death.
So, Dan, are there any debts that the estate wouldn't be responsible for?
My clients will call and they'll be very concerned that, this bill is going to get paid and how does this bill get paid? And the first thing that they should really do is just take a deep breath, because when somebody dies, people understand that sometimes there's a little bit of a disruption. And our goal is to try to minimize that disruption, by the way. But, for example, in the probate process, if you have a will and it goes through a probate process, creditors have a period of time that they get the chance to file a claim. And it's approximately 2 months after we open up that probate, so fairly quickly after death. And for example, like a credit card or something like that, if they don't file a claim, by law, you don't have to pay that. And we're not trying to avoid debts or things like that, but they didn't follow the process. And there is a process by law for creditors to get paid. So I typically tell people to wait to pay creditors and to see who files claims and who doesn't. Other people, get paid a lot faster, like a funeral home or things like that. By law, they have a priority. But in general, the most important thing is to not be too hasty to pay all claims. The other thing that happens is that sometimes immediately the hospital will file a claim in the estate. Well, you don't want to pay that right away anyways, because oftentimes insurance ends up covering those types of things. So it's a wait and see, but I always say everyone who has legitimate debt will get paid, but we don't have to pay them tomorrow. When someone passes away, there's protections and things that allow us a little time to get our ducks in a row.
So what do you tell your clients when they call after a death has taken place?
Yeah, a lot of my clients will call me very quickly. Sometimes it's the day of a death, and it's always sad to get those calls. Sometimes I've worked with these families for years and go back, and so it's always a difficult call to take, but unfortunately it's a common one in my business. Yeah. And I'm surprised sometimes that the family members are very anxious they're concerned that there's something that they need to do that minute from the legal side of things. And what I found is it's helpful to, again, tell them to not worry right now. Focus on the final arrangements, focus on family, be there and present and through that tough time, because they need to be with family and to grieve. There will be time to take care of the legal side of things. And we don't have to wait long, but wait, get the final arrangements taken care of and honor your loved one. But there are practical things that we do talk about. We talk about things like securing the house sometimes. Unfortunately, there's a lot of break-ins and things like that when people die. It's a sad world sometimes. And so we talk about some of those practical things. But for the most part, what I want them to do is to focus on their loved one who's passed away, being with family, and we'll address the legal things as soon as they want to, but it doesn't have to be done that day.
We've noticed that a lot too. Families will come in and of course, they feel overwhelmed with all the decisions and all the things that have to be taken care of in a short period of time for the services. But everything else can wait. And we try to get back together with families about a week after the services to help them with some of those things as a guide. Here's a checklist of things you're going to need to address within the next days, weeks, and months ahead. And I think they find that very helpful and calming. Another thing that comes up often is Social Security. So families often ask us about Social Security, and we do notify Social Security at the time of death, but families would need to do so as well, but it doesn't have to be done today. We talked a lot about a will. Where would you advise families to keep a copy of the will so they have access to it?
Well, that's probably the question that gets asked every single estate planning appointment that I have. What do we do with this? Here's this beautiful document. What do we do with it? And practices vary, but my practice is that the client should have the original will. And so what I recommend is that they keep their original will, which, by the way, in Nebraska, it's a little old-fashioned, where if we have the original ink-signed will, we have an easier process versus if we have to introduce a copy. So that original will is important to keep track of. I recommend that they keep that in a safe place that's going to be safe from a tornado or a fire, like a bank safety deposit box, maybe a fireproof safe at home, or just some place that would generally be protected. And then I recommend that they have physical copies or electronic copies, which I call their working copies. I tell my clients to review their plan, read through it every year. You'll be surprised how much can change in your thoughts and actions, or your thoughts and goals in just 1 year. And the changes in your own family. So I say have those working copies where maybe in a home office or places where you keep your tax things where you can grab those and read through them, or if in an emergency you needed to grab your power of attorney document for your spouse, you would know and be able to easily access those. I think a follow-up question that people ask is, well, how do other people know where these documents are? And it's great that the attorney knows, but communication is key. Just probably as the same as with funeral planning and pre-planning and communicating that to the kids and to the other family members. It's important that, if you're going to trust your kids to manage your estate or your spouse, that they should at least know where those documents are in the house, that you have them, and that you've appointed them potentially to be of service to the estate in some way, maybe as an executor, maybe as in some other role. But again, it's that communication saying, here's where I keep the documents. I used this attorney. If nothing else, call this attorney. He'll have all the things that you need.
So we have a planning guide that we share with families as part of service to them. It's a 24-page guide where they can document their wishes when it comes to cemetery and funeral planning, but also what their estate plan looks like. It covers a lot of things, and one of those things, talks about the location of the will. But this guide is very helpful at the time death occurs. So it's kind of like a gift to your family.
I'm a big fan of that. That's an excellent tool. And that is very much in line with that communication that I think is so important.
As far as where to keep the guide, it's very important that your family, one, knows that it exists, but two, they know where to locate it. So I always tell families, if they have a safety deposit box, make sure the family knows it exists, but then also have a secondary name on that safety deposit box. Because if you pass away and nobody has access to that, they may not they may not know what your wishes are until, of course, after a service takes place. And so we find it very helpful if a family brings that in, because it covers everything from obituary information, what my wishes are. And sometimes people get very detailed as far as, here's what I want for the music, here's what I want to wear, here's what I want for jewelry and passages and things like that. So I think it's important that, one, everyone knows these documents exist, and of course where they can locate them and that they have access to them. So
I agree 100%.
yeah. Now, can you tell me a little bit about a living will?
So living wills that moniker is a little confusing sometimes for the clients because it's not a will in per se. It's also sometimes gets confused with like a living trust. But it's generally that's what people refer to them as. They're really called healthcare directives. And the healthcare directive is usually a part of and very similar to a medical power of attorney. Typically, a person will have both a medical power of attorney, which would say that if I can't make my own medical decisions because I'm incapacitated or have a terminal illness, that I have a chance to appoint someone who I think would be a good decision maker. Maybe my spouse, maybe one of my children, maybe a couple of my children. The living will is a specific portion of the medical power of attorney, or it can be a separate document that has specific end-of-life decision-making points in it, such as the wish that extraordinary measures wouldn't be taken if certain health situations are present. So for example, again, you have someone who has permanent loss of consciousness. That living will portion might say, well, I don't want to be kept alive artificially or be on a ventilator. And so those are very, very popular. Not everybody likes that, but it is an important discussion and one that people are ready to take. And the consensus is, the one of my clients says, oh yeah, I don't want any of that stuff. I don't want to be kept alive. I don't want to be, just sitting in a hospital bed for months on end when there's no chance that I come back to a cognitive life. And so there's many protections built into the law. Those can't be so that abuse and things don't happen. But at the end of the day, it's your chance to have some control over that situation and your own power to say, I'd like to be left to die a natural death rather than be kept alive artificially.
Yeah, and I can't imagine having to make a decision like that. And so basically it's saying, if there's little or no chance of recovery, would I want to be put on life support or not?
Correct. That goes that's exactly a great description of it. Mm-hmm. Sometimes people get the living will confused with a do not resuscitate order, which would be, and they kind of blend those things together, and that's a little bit different. A do not resuscitate is usually sort of a specialized, it's not a contract, but it's an agreement between you and a particular healthcare provider that if your heart stops, if you need CPR, that they won't do it. So think of going into a nursing home, the person might sign a do not resuscitate, but it's just applicable between that client or that patient and that nursing home. There's no sort of general do not resuscitate. But the living will focuses more, again, on those terminal illness type situations, permanent losses of consciousness, and just allow really family members or healthcare providers to honor those wishes that you not be kept alive artificially.
I think it really gives families peace of mind knowing that they were able to follow the wishes, because again, like I say, nobody wants to have to decide when you take your final breath. And I think that's a very emotional decision. And so the feedback we get from families is that, they're very thankful that mom or dad had this document so they didn't have to make that decision. So we certainly encourage all families to do that. I know even if you go in for a medical procedure these days, they have you sign. Is that a living will that they have you sign, or is it?
Yeah, generally that would be more of the medical power of attorney, but that sometimes includes, again, sometimes those terms, oftentimes that it is included in a medical power of attorney. So I always, my documents in that respect are always just one document. So I always say whatever the physician asks for you, you don't have to worry about like, oh, do I grab my living will or do I grab my medical power of attorney? I say anything that's health related, you give them this document. Okay. And so I was in the hospital a little over a year ago with COVID, and And once I got to the hospital, I knew I was going to be okay. But they were asking me about the power of attorneys, and I thought that was kind of odd to be on the other side of things and think, wow, what's going to happen here? So, but it is standard. They'll just about ask you almost any time. My older clients, I mean, they just go in for routine exams. They're asking for those.
Can we talk a little bit about power of attorney? Because we deal with power of attorney quite often. So I think a lot of people are under the assumption that a power of attorney continues on after death, and that's really not the case.
That's absolutely correct.
Okay.
And that's a common misunderstanding. And I can see the client's point. So in some cases, my clients might have had their son or daughter helping them as being a financial power of attorney for 20 years and doing transactions for them, and everything's been going great. And then mom or dad dies, and that child goes into the bank to do something, and they're told they can't do it. And they say, well, what's wrong? I was doing this for 20 years for mom and dad. But by law, those power of attorneys end at death. And we've just entered a new phase, and that's really where a will or maybe a revocable trust or some other mechanism needs to kick in at death. So yes, the power of attorney just stops at death, but that can be a rude awakening sometimes for a family member.
It really is. Families will come out to make arrangements, and they'll say, well, we have the power of attorney. And, a lot of people really don't realize that does cease at death. And so how do you advise families? I mean, who makes the decision after a death occurs if power of attorney ceases?
And what decision do you?
Well, for example,
who's in charge of the funeral planning?
Yeah, there's a lot of things that have to be decided at the time of death. And so, unfortunately, if there is no, would it be a personal representative, or I guess would that be the?
Yeah, that would be. Well, that does, and that gets into that can be difficult, especially in the context of like funeral planning. Who's in charge? How does it get paid for? We need a little bit of time to get some liquidity sometimes in the estate, but that's really why the pre-planning of the funeral is so important, that there doesn't have to be someone in charge. We still might have, how do we pay for it, but sometimes if they can prepay the funeral or things like that, that's very helpful. But that's, again, why that planning is so helpful, so that you don't have a situation where we don't have a personal representative appointed yet. Sometimes in Douglas County, that can take over a week, just depending on how fast the court is moving. And so the funeral home might not know really who to take directions from. Nebraska law provides an excellent tool to handle at least the funeral scenario that we were talking about, where there may be some time before we have the will into probate, and that will only becomes effective once it goes to the court and has a process there. So Nebraska has a Disposition of Final Remains Act, and other states have something similar to this, where you can almost give someone like a power of attorney. It's not a power of attorney because those end at death, but it can say this person has the final say on my funeral arrangements, whether I'm cremated, whether I'm buried. You can put as much detail as you want into that, but it's a legally enforceable document, and it has to be reasonable. I've had clients that say, "Oh, I'd like to have this with my remains and dumped in a national park," and it's like, well, that's illegal. Yeah. That really would fill that gap, especially as it relates to funeral planning, and I think it's an underused tool.
I would agree. Obviously, we encourage pre-planning because that allows your family and your loved ones to follow your wishes. But if they don't have those plans, we would encourage that disposition of final remains document to be signed.
Yeah, it's definitely not a substitute for pre-planning. And you had said something earlier that I wanted just to tag along with was, you had said that you've never heard a client or a family say, "Oh, I wish they didn't do pre-planning," right? And I hear the same thing, or just a little bit different. When I talk with a family, what I love to hear is they said, in admiration of mom or dad who passed away, they say they had it all ready to go. They had the funeral planned, and we didn't have to worry about anything. And I think, job well done.
Yeah, it really is. It relieves a lot of stress and hardship on the family when they don't have to worry about the emotional, or there's emotion there regardless. When somebody passes, there's an emotional aspect to it, but the financial aspect doesn't have to be a part of that. And when a family pre-plans, they're removing that financial burden from the family and from the people that they leave behind. And that financial burden can be very overwhelming. A family's grieving, they're dealing with the loss of their loved one, and to have the financial burden added on top of that. Because unfortunately, the funds for funeral services are due prior to the service taking place, and that really can be a hardship for many. So what would be the most basic version of a living will? If I decided I wanted a living will, can I just go home and write one?
Well, there are formalities that you have to abide by. Generally, I wouldn't recommend that people write their own living wills or their own last wills or anything of that nature. There are technicalities and requirements under the statute that you have to meet for that to be valid. For a living will, for example, generally that has to be signed and either witnessed by two people or can be notarized. But Nebraska provides what we call a statutory form. The laws around living wills and medical powers of attorney, they are all dictated by state law. And so states have generally produced their own, what we call a statutory power of attorney. And you can get that on the internet for free. I recommend that you work with an attorney. It's one thing to have the form and another how it works and what are the ramifications of certain decisions. But if you wanted to, that would be perfectly acceptable to find one on the internet. You just have to make sure it gets executed in accordance with the law.
So do you ever have siblings or family members have disagreements, either with a will that's already in place or if death occurs and there's no will?
Disagreements about money in a family? Never.
Money, yeah.
Yeah, it's sad. We see it all the time. And so one of the things is good estate planning on the front end can certainly minimize that. Our goal is to eliminate that type of thing by having clear documents that are not open to interpretation, that are completely solid, completely valid, and we do many things to safeguard that on the front end. Sometimes there's personalities involved that it doesn't matter how clear it is. A sibling group might just have a history of sibling rivalry and dissension and years of hard feelings. Mm-hmm. And that's difficult. The only thing we can do in those situations is say, we're going to follow the law. You can behave however you would like, but we're going to do things the right way. And we will make sure that the mom or dad's wishes are fulfilled. And we can't always control other people and how they behave. But that's why we do estate planning, so that there's not ambiguity, as little room for argument as possible. And we follow the law after someone dies.
We are challenged with that sometimes as well, where families will come in, siblings, and they don't have, there's no plans in place. And they're trying to agree amongst themselves at what mom or dad would have wanted. So, one child is saying, mom or dad wanted to be cremated. The other is saying, no, they want a traditional burial. And then it really becomes a kind of a battle. And as a funeral home, we can't get in the middle of that. But as a funeral home, we really have to have everyone come to an agreement. How is that handled on the legal side of things? Who gets to ultimately make that decision?
The first thing is that when you're on the other side of things after a client has died, often I'm representing the person who is the personal representative, or maybe their trustee, the person that they've trusted to carry out their wishes as it relates to their assets. And what I always preach to those individuals is to be very forthcoming with information. Be very transparent. The more transparent that you are in that situation, that may not 100% solve problems between those siblings, but at least that's not another thing that's going to be adding to the stress or maybe to the distrust that there can be within a family. So I like to say open and honest at all stages, and communicate, maybe over-communicate just a little bit. And it's amazing that when you take away some of a disgruntled family member's firepower by saying, here's the information, Here's what we're doing. This is how long we think it's going to take. We think it's a good decision because X, Y, Z. It's when people try to say, when someone is in charge of an estate and maybe they want to play things close to the vest, or it's just my way or the highway, and I'm only going to do the minimum type of communication to the people who have interests in this estate, that can be a recipe for further dissension, unnecessary hard feelings, because sometimes there's just distrust. And so good communication, transparency will go a long way in smoothing those things out.
Yeah, it really allows siblings to come together to say, this is what mom and dad would have wanted, or this is what mom and dad did want, this is what they planned. We find that including the children in sharing your plans with the children is beneficial, so everyone's on the same page. There's no surprises at the time of death. But we also find that making those plans and arrangements and then letting the children know what those are is beneficial as well, because sometimes children don't want to talk about it. They might think something is wrong. It's just an uncomfortable conversation to have at times. They just really don't want to think about your demise, right? So we find it's important to, make those decisions, then share those decisions with your family so they know, here's what mom and dad want, here's what we're going to follow. We find that it keeps those disagreements minimal.
Without a doubt. I always say, if anybody then has a disagreement, they know who to blame. It's mom or dad.
That's true.
Right? And I'm surprised, sometimes my oldest clients, maybe clients that were the greatest generation type of generation, I see a general unwillingness to share information, not just about how the will reads or the trust reads, but even what assets they have. There's just something a little bit that was more private in those generations, and I really recommend that people have that conversation about death. That death doesn't have to be something that we're scared about or we don't talk about. But I always say, have a meeting at Thanksgiving when everybody's around the table and say, this is the decisions we've made. If you have a problem with that, it's on me, and it's not, and I don't want any. I tell my kids, no matter what happens, because I see so many horrible things that families, and I just think, how did this happen? I just make my kids promise, do not fight with your siblings when your mom and I are dead.
It's funny you bring up Thanksgiving and Christmas, because we actually hear that a lot. We'll meet with families and they'll say, well, everyone's getting together at Christmas, everyone's getting together at Thanksgiving. And so, they really want to have a conversation about it. And that's a chance for them to let everybody know, here's what we've decided, here's what our wishes are. And, I think everyone is very appreciative at that point, and they just kind of follow what mom and dad's wishes were. We find if plans aren't made, that people will, it's emotional overspending. People will spend more out of guilt, and, they want to do that one last nice thing for their loved one. But by pre-planning, they're also locking in their prices and stopping that rate of inflation. So I think we can both agree that pre-planning is important. It's an important component of estate planning as well.
Without a doubt.
Yeah. So what is the difference between a will and a trust, and when might it be more appropriate to use one over the other?
Sure. There's a little bit of a misunderstanding that they're sort of in competition with each other, and some lawyers prefer wills and some trusts. They're both tools. They're tools that operate under a little bit different set of laws. But generally, when people say, do I need a trust? They're talking about a revocable living trust, or they go by different names too. And I do like using revocable trusts. I think they have a lot of benefits to them. People there's privacy concerns that people have that a revocable trust allows you to kind of keep a little more private than a will, which can be a very public thing. But the number one reason that people like revocable trusts is that it's an option to avoid that probate system that we talked about, and which is can be a very helpful thing to do. It definitely makes things cheaper and faster at death. But sometimes the probate avoidance argument is a little hollow, especially in a state like Nebraska, where the probate process is not very onerous, and there's a fairly orderly process that doesn't really take all that long. And an ethical attorney shouldn't be charging you excessive amounts to do a probate. It should be a fairly reasonable expense. Reasonable being in the eye of the beholder, of course. But there's other states where I feel very differently. I'm also an Iowa attorney, and I think the probate process is excessively long and can be excessively expensive just from a court fee perspective. So where you live can play into that. One of the number one reasons you should always have a revocable trust, though, is if you ever have real estate, maybe a cabin, or even a timeshare in another state, because then a revocable trust can allow you not to just to avoid probate in your home state, but a second probate to deal with real estate that is located in another jurisdiction. So whenever I have here clients that say, yeah, we have a cabin in Missouri, or we've got property in Oklahoma, or that's always been our dream, we're probably going to do that in retirement, I say, let's get a trust, because that will be a significant savings. So it's just another tool, and most of my clients can benefit from that. But not everybody needs that as well, too. So I try to fit what is going to be the best way to accomplish the client's objectives. And if that's a revocable trust, that's great. And if it's a very simple will and some beneficiary designations on things, so be it. We're going to do and have the best plan for that client.
So you can still name a personal representative within your will, correct?
Correct. If you have a revocable trust, you will always have a will as well, too. And that's called a pour-over will, that usually says, well, if I have anything that needs to be probated, the beneficiary is the trust, and then the trust has all the details and all the things that you want to do, and can be very simple or very complicated. But under the trust, the person who has the authority to actually make those decisions and to distribute property, that's called a trustee or a successor trustee. But they act very similar to personal representatives.
So estate tax, is that part of a trust, or does that protect the family from estate tax?
That's a common misconception about trusts in general, that having a revocable trust will help you avoid taxation or minimize that, or like it's some sort of magic tool. And that's not true. So the taxation is the same whether you use a revocable trust or will or beneficiary designations. The states are very smart. They're going to get, and the government's very smart, they're going to get their tax dollars. Now, the main efficiency that you get from a revocable trust is maybe avoiding that probate, avoiding those 2 probates if you have real estate in other states. Mm-hmm. That's the main thing. It's more of an efficiency and an attorney cost reduction rather than taxes. While there are trusts and ways you can structure trusts that minimize taxes, especially federal estate tax for a high net worth couple or a high net worth person, those solutions are not necessarily only applicable to revocable trusts. You can do those things with wills too.
So when you're meeting with families and they're setting up their estate, how do assets play into that when it comes to cars, homes, the pool table, the TVs? I mean, do people really plan out what belongings go to what siblings or what family members?
Yeah. Some clients do, as far as distributing their what we call tangible personal property, or I say household belongings. This could be everything from the jewelry to family heirlooms. I have a family heirloom. My family's not that much into that sort of thing, but I have for example, I have a rolling pin that is a solid piece of wood. And my great-great-grandfather, that was his job as a 7-year-old when he came over to this country to carry on the boat, because that was important. That's how they made bread. They were poor, immigrants. And so that was important to me, that my mom would pass that down to me. So some people, it just depends. Some people are very into that. And Nebraska law, whether you use a revocable trust or a will, says that the legal way to do that, in a very convenient way, is to make a separate list. And that can be handwritten and signed and dated. And if it's found with the will, that's going to be considered to be as an enforceable part of the will. So it's a good way to remove any sort of doubts about who gets what property. If it doesn't get addressed, if you have a harmonious family, then they have some flexibility in how those things get divvied up. But I always talk to my clients about that, and many people will go and take that to heart and list out a lot of things that are very important, and some will just ignore that. And to each his own, but they have the opportunity to do so. Mm-hmm. Okay. So there's also a lot of questions sometimes I get. A common one is, I always say mom or dad, but it's any client. And the family calls me and they say, when's the reading of the will? You see
Yeah, I
that,
hear
and you
that.
see that in the movies. And Knives Out was a recent one where I always have to laugh how things are done. And I don't know the history on that. I don't know if there was a time that was valid. That doesn't really happen. The law, I think, has sort of provided a way for people to be informed. But that is for example, if you are an heir, meaning that you are a close family member, I'll just leave it at that. Say mom or dad dies and the kids are the closest living relatives. They would be entitled to know that a probate has been opened, and they can go and look for themselves what the will says. If the clients have used a revocable trust, Nebraska's trust code says that when a trust becomes irrevocable, or so can no longer be changed, so that's usually at death, then within 60 days, the trustee of that needs to send a copy of the trust to people who are actually going to be receiving something. What's nice about that is they don't have to send that to anybody who's not receiving, so that's a privacy issue that makes trust very popular. But I think that process has generally replaced that reading of the will, and oftentimes that would place the attorney kind of in a bad spot because the attorney is not representing, this is also a misconception, is not representing the estate as a whole. That's not a thing in this jurisdiction. You represent people, so oftentimes the attorney is just solely representing the personal representative. So there's privacy issues and things, so there's usually not a reading of the will. Now, with that said, I've had times where I know the family, we've served the family, everybody comes in, we know that everybody's on the same page, and yes, we talk about it, but there's not the big formal dramatic thing that you see on the that you see on the movies. So just again, Hollywood sometimes will convince us that there's ways that things are done that really don't exist.
Sure. Okay. So what are some of the key things that people need to think about before going into the attorney's office for the first time?
Well, generally, Angela, that what I am going to need at that first meeting is I'm going to need to have an understanding of the pieces of the puzzle, and which I think are the assets, the types of assets, who owns them. If it's a married couple, are these assets that are jointly held? Are they individual? I just need to have that information. People oftentimes are very concerned about the value, like, oh, these stocks are going up and down. I'm less concerned with value. I like to generally know how much, what the value of a client's assets are, but it's more important the types of assets, whether there's a retirement account, whether an investment account is a non-retirement account. Those have very different taxation at death, and so I need to know, okay, we have this much in this type of an account and this much in this. Life insurance, people forget all the time what kind of life insurance they have, which is one of the fastest ways to get liquidity in a state, has very good tax benefits to it. I want to know about all those things. And so to be prepared to discuss those things, you'll be surprised how many times clients come in, well, I really don't know what I've all got, and it's harder to get that information from that type of client. But from there, we're just asking a series of questions about their family, and things the client has to answer are things like, who do I trust to make financial or medical decisions if I'm living, but something has happened to my cognitive thinking? And people have to think in a couple different layers to that. People say, well, of course, my spouse. Well, the time when people need power of attorney documents is usually, it can be any time. We never know what's going to happen, but it's usually later in life. Mm-hmm. And we can't count on the spouse to be there later in life. They might have been predeceased. They might have their own medical issues they're dealing with. They might be divorced. And so we think, okay, well, who's our alternate? Which kids have the skill sets to do that? Who do you trust to make that type of decision? And so you have to think about this at different times, and what happens if the people we are trusting to do something aren't there. We talk a little bit about, I try to get an idea of what are their objectives. I ask about a typical client about their children, if they have children, and I want to know how old they are. If you're a young family, meaning you have minor children, no family that has minor children walks away with a simple estate plan, because providing for minor children is not a simple matter. It has to have some thought and things of that nature. Maybe the children are adults, but I want to know, how do they handle money? I want to know, are they responsible? Do they have a drug or alcohol problem? That's very prevalent. Does anyone who potentially might receive benefits from your estate or trust, do they have some sort of a disability? And that's very prevalent. You need to ask about that because there's different ways to address all those situations. And so that they just don't get a off-the-shelf document that you've actually put in the thought and thought about all the contingencies. So oftentimes people's lives are simple, and we don't have to have a complicated plan just for the sake of complication. But a lot of people's lives aren't that simple, and so we have to address some of these sensitive subjects.
It is interesting that you mention people forget what they have, and I think that's a great point because the planning guide that we have, it's really an outline for them to kind of document all their assets versus their liabilities. And so on there's a place for them to document, what life insurance they have, what bank accounts they have, and what professionals are in their lives, who their attorney is, their medical providers, people that need to be notified at the time of death. But it's really a guide. It's a tool that guides them through all of these things and actually would prepare them to come and visit an estate planning attorney as well. So a lot of similarities there.
Very helpful. That's a very helpful tool.
In conclusion, estate planning is important for many reasons. And by including a cemetery and funeral planning component within your estate plan, takes a considerable amount of stress and pressure off your loved ones. It also helps ensure that your plans will be carried out according to your wishes. If you have any questions for Dan, please feel free to leave them in the comment section below. And if you want more content like this, please make sure to hit the like button and subscribe.